Hello, my name is Aslam Moolla. I am a CCMA and Labour lawyer. In today's video, I want to talk to you about how to postpone a disciplinary hearing in South Africa if you cannot attend the hearing and without obviously getting dismissed because you didn't attend. So I have a short article that I've written on my website, which you can access on the link down below, which explains how to postpone it and also goes through an example email that you can send to your employer if you cannot make the hearing. I made this video in case someone is unable to read the article and if they prefer to watch a video instead. So let's go through it. What happens when you get a notice for a hearing and you can't attend? Firstly, the most important point is you cannot deliberately avoid the hearing. You have to have valid grounds. If you try and avoid the hearing without valid grounds, you can be dismissed for that. So the next question that comes to mind is, what are valid grounds? What are acceptable reasons for a person not to attend a disciplinary hearing or retrenchment consultation or any kind of workplace hearing that's meant to take place at work? The first valid ground is a genuine illness. So if you have an illness that prevents you from attending the hearing, then that would be considered a valid ground for not attending. So it's very important to make sure that you have a medical certificate and you are able to prove that you had the illness. You can't just wake up in the morning and say you had a running stomach and that's why you couldn't attend the hearing. Sure, that may be true, but at the same time, the employer can say that you tried to deliberately avoid the hearing and that's why they had no choice but to dismiss you. So it's important to have a medical certificate. That means go to a doctor, go to a clinic, get some kind of proof to show that you were genuinely ill and couldn't attend the hearing. That's the first example. The second example is a family emergency. Now, what do I mean by family emergency? This could be where someone has passed away in the family, someone had to be admitted to a hospital, any kind of situation that warranted you to take drastic action because of that family emergency. Maybe your child was exceptionally unwell and had to be rushed to the doctor. Again, very important to keep certificates, keep evidence, some kind of proof to show that the emergency existed. That's the second ground. The third ground is where you did not receive enough time to prepare for the hearing. Now, according to law, an employee generally has between 24 and 48 hours to prepare for a disciplinary hearing or retrenchment consultation. If the employer gives you the notice at 9 o'clock and asks you to have the hearing at 3 o'clock on the same day, that would be insufficient time to prepare. So that would be a valid ground. However, if the employer had given you enough time between 24 and 48 hours, then you can't use that as a reason. So in summary, there are three essential grounds as to why an employee cannot attend a disciplinary hearing or retrenchment. Number one, genuine illness. Number two, family emergency. And number three, enough time to prepare. If you do not have the valid grounds and you don't attend the disciplinary hearing, they can continue in your absence and you can be dismissed for that. So it's important to understand that. Now, what happens if the disciplinary hearing has already passed and you couldn't make it? I get this question a lot from my clients. The next step is simply to contact the employer and explain your situation to them. In other words, you can send them an email and ask them for another date for the hearing. But make sure you have proof that you can attach to that email. That's very important. So I have an example on my website. Click on the link below of the type of email that you can send. Basically, it's going to be along these kind of lines. Dear Mr. Employer, my apologies for being unable to attend the disciplinary hearing scheduled on the 16th of April. I have been very ill. I have been to the doctor who diagnosed me with bronchitis. Here's my medical certificate from the doctor which shows this. It's attached to this email. Kindly provide me with an alternative date for my hearing, as it is my legal right to be heard as well. I look forward to hearing from you. That's an example. So if you have the proof, send an email like this to the employer. You want a copy of this email, click on the link below, which takes you to the website which explains this part of how to postpone a disciplinary hearing. Now, what happens if you send the email and the employer refuses to give you a new date for a hearing? Then you send up a follow-up email saying, listen, I sent you an email, I haven't received a response, what's going on? Please reply to me. If it turns out that they've dismissed you and they refuse to give you another date, then you can go to the CCMA and open up a case for an unfair dismissal. If you need help with filling in the CCMA form, or you need help with whether you have a strong case or not, please click the link below and make an appointment with our office. I look forward to speaking with you soon. Take care. Bye.